Welcome to PEP 167, 166 part 2, not sure. Let's call it 167. This is a very special episode. And when I say special, I mean specially ramshackle, because it is just me. I try so hard to keep this podcast from being just me. I know that I am surrounding myself generally with people who are much better than me, like, say, Dr. Dave or Richie or Melina or Bill, all these people. And I know that it's a bit boring listening to one person. The sound quality isn't great on my laptop because I still haven't worked out how to attach a microphone to this damn thing. But this is an emergency. We've got to get this Supreme Court stuff out because this is aging fast, and we have the very special Tri-podcast coming up with Dave and Richie on PEP 168 on Friday, and neither of them are really all that interested in the Supreme Court stuff. So I need to get this out of the way. I don't know how long it's going to go. I'm going to try and keep this one on the short side because, hey, you've still got 3 hours from yesterday to listen to. But we'll see how long it takes. I'm not going to skimp it, but if it's anything more than an hour, 20 or an hour and a half, that's more than enough. We don't need to push it to the 3 hour limit this time round. There's essentially two sections for you here. I have a section on the administrative cases for the Supreme Court, where there are 4 of them in the last few weeks, and a section on Trump's trials, and there are 2 of them. There's usually, when we get to the end of June, that's like the end of the term for the Supreme Court, and that's kind of when they, just like a uni student, they leave everything to the last second, and they spit it all out at the last second, and that's what they've done this time round. There are about 10 other cases that they spat out as well. A couple of them are interesting. I may pump some of them into a Chaz Unleashed in the future. I may not. We will see about that. Let's kick off straight away. No correspondence on this one either for these little special holiday PEPs, especially given I have no idea what you said about PEP 166 because I'm recording this directly after PEP 166. So there are 2 sections. Let's get into section 1, the administrative section. All right, so let's start off with SEC versus Jarkesy, I think it is. Jarkesy. SEC versus Jarkesy. And this was one of the rare cases that went along party lines. 6-3. And the facts of this case: George Jarkesy is a right-wing radio host and former hedge fund manager who lied to investors in the early 2010s. Well, allegedly lied. No, actually, he was being found guilty. So he lied in the early 2010s about 2 funds that he ran. He lied about the management team, the types of investments, the business partners that he worked with, the asset values of the funds, all kinds of stuff. And he was charged with violating federal security laws. Now, back in 2010, the Dodd-Frank Act, that was after the financial crisis, after the collapse of a number of institutions, that gave the SEC 2 ways of penalising shysters. One was through the federal courts, which is what they always did in the past, so they could keep on doing that. Alternatively, they could now prosecute them through administrative proceedings that were run by administrative law judges, or ALJs, who work for the agencies themselves. So the SEC could basically prosecute you in-house instead of going through the court system, which is a lot cheaper, a lot quicker, a lot less fuss. The SEC took Jarkesy to one of those administrative proceedings, and he copped himself a $300,000 fine. Jarkesy then appealed to the federal courts, saying that him going through the SEC tribunal system, it violated his 7th Amendment rights to a jury trial. What's the 7th Amendment say? It says, in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. Not might be preserved or could be preserved, shall be preserved. Now, the Supreme Court, as I said, ruled 6-3 that he was at least partially right, that he should have had a jury. Roberts was the one who wrote the majority ruling. What he said is that what matters essentially is what the charge is. In this case, Jarkesy was charged with fraud, which has been part of the common law since 1791. So Roberts said, the object of this SEC action is to regulate transactions between private individuals interacting in a pre-existing market. But before the SEC came along. To do so, the government has created claims whose causes of action are modelled on common law fraud and that provide the type of remedy available only in law courts. This is a common law suit in all but name, and such suits typically must be adjudicated in Article 3 courts. That's the federal courts. So essentially, he's saying this really should be in the federal court. It's a fraud case. Fraud cases should be in federal courts. Why are you pretending this is special? It's just a fraud charge. It should go to a court, just like every other fraud charge should. He also noted that money damages are the prototypical common law remedy. They charge them $300,000 as a fine. The civil penalties in this case, he said, are designed to punish and deter, not to compensate. They are therefore a quote, type of remedy at common law that could only be enforced in courts of law. So he's saying also the fact there's a fine is also relevant. Now, what does precedent have to say about all this? There is something called the public rights doctrine that says that many lawsuits that arise under federal statutes are not subject to the Seventh Amendment, and thus the government is free to try those cases in an administrative proceeding without a jury. That precedent was set in 1856. Okay, so there's a lot of precedent that says that there are this whole school of trials that aren't covered by the Seventh Amendment. So it's not so weird that lots of stuff aren't covered by the Seventh Amendment, even though the Seventh Amendment sounds very conclusive. Sotomayor in dissent said that by 1986 there are over 200 federal statutes calling for trials before ALJs. So the majority position that they should go to a jury trial, it's fine in theory. I mean, jury trials are great, but now you've got a situation where all these statutes are assuming that they can use ALJs. So do they all become defunct? Is this just going to throw the whole of administrative law into chaos because they've got all these statutes that are pushing them towards illegal ALJs instead of jury trials? Now, in the case of the SEC statute, the one in question, it didn't matter because they had two options. But lots of tribunals and organisations and agencies don't have two options. They only have one. Like, for instance, the Occupational Safety and Health Review Commission, the Federal Energy Regulation Commission, the Federal Mine Safety and Health Review Commission, the Department of Agriculture, heaps of others. They only give you the option of going to the in-house tribunal. So are they screwed now? Is every single ruling they have made in question? Does that mean that workplace safety laws suddenly have ceased to be enforceable unless Congress passes a new law, which we know they're probably never going to do because they don't do that anymore. They're not in the business of passing laws anymore, Congress. Sotomayor cited as her main precedent herself a case from 1977, Atlas Roofing versus OSHA, which held that public rights doctrine applies when Congress passes a law authorizing suits by the federal government that are unknown to the common law. That's the quote, unknown to the common law. She cited that at precedent and said, so this should be fine, the SEC one. But Roberts said, no, we'll follow your precious precedent. It says that the federal suit should be unknown to the common law for it to be immune to the Seventh Amendment or not covered by the Seventh Amendment. But in this case, he said, we're respecting precedent. This was not unknown to the common law. The regulations for the Occupational Safety and Hazard Act were unknown to the common law. They were new kinds of regulations, these health and safety regulations. Sure, they can go to your precious tribunal, but the fraud case, that's very known to the common law. So this does actually respect the precedent of Atlas. And it should still go to a jury trial. It should be covered by the 7th Amendment because it's known to the common law. Now, I actually have sympathy for the majority on this one. I have to say, in fact, I pretty much am ruling with them. I'm with John Roberts on this one. The 7th Amendment is there for a reason. It's supposed to protect defendants, right? It's supposed to protect the little guy. That's why it's there from big government, right? It protects them how? With federal rules of evidence, which are, by the way, a lot stricter than tribunals, which they can do whatever the hell they want. An independent judge, the tribunal, the judge is part of the agency that's charging you. Your peers find the facts, like in a jury, they're the ones who are finding the facts, rather than someone from the same agency that is judging you and charging you. Importantly, by the way, those ALJs, they can choose what evidence they want to admit. They can hearsay, whatever laws that you think apply for evidence, they don't apply in these tribunals. They can do whatever they like. They can cut whatever corners they want. But here's the thing. If that gets then appealed, and it gets appealed to a federal court, which sometimes happens, the federal court, when they review their judgments, have to take their facts that they found. They can't re-examine the facts. They have to take the findings of the factual findings of the tribunal. And that might include hearsay. It might include stuff that the court would exclude if it had gone through the court system. So these tribunals actually infect the court with dodgy evidence. So there is a very good reason to avoid them if you possibly can. Neil Gorsuch is big on the little guy. I've got some stats coming up at the end about justices, and Neil Gorsuch is he's ruled against against the government more than any other judge on the Supreme Court at the moment, and he was big on this case. He noted a study found 90% success when the SEC tried people in-house compared to 69% success when they did it through federal courts. So you can see when you have a dodgy system, more people are found guilty. So he said, let's give them due process, send them to the federal court. Bottom line, if you can just declare a standard common law like fraud as administrative, and you can rush them through a system with no due process, what's the point of the 7th Amendment? Why is it there? So I have a lot of sympathy with the majority on this one. Gorsuch also said, look, this is no big deal. This is a quote from Gorsuch. The court hardly leaves the SEC without ample powers and recourse. The agency is free to pursue all of its charges against Mr. Jarkesy and is free to pursue them exactly as it has always done until 2010, in a court, before a judge and with a jury. Now, I should note, there is a bit of hypocrisy here because the court isn't always keen to exclude jury trials. Not keen. The court isn't always so keen on jury trials at the expense of skipping them. For instance, the court has long held that companies can force their workers to sign away their rights to sue the company in a real court, and they have to resort then to using a private arbitrator instead. Quite famously, there was a case in 2018, Epic Systems versus Lewis, and I think Gorsuch, from memory, might have found himself on the wrong side of that one. In that one, the court held that an employer can simply order their employees to give up their right to a jury trial under pain of sacking. So they're a bit hypocritical sometimes, the judges, with this whole, you need a jury thing. But let's think about the dissent for a second. Why do we care about this? The effects might be problematic. Look, I should say, if this is just about fraud and the obvious analogues to fraud, then it's probably not a big deal. All right, they are like then Justice Roberts' precedent, that's fine, right? But if Roberts just ruled out all monetary fines, like it sounded like he was almost leaning towards, for at least for administrative law judges, then that could have a huge effect. Why? Because like I said, going to court costs a lot of money. Requiring the agencies have to spend the money on court battles to enforce their regulations, that means a lot less regulation enforcement, which is going to be a theme you're going to see over the next few cases. Or, by the way, it could go the other way, which is it could lead to agencies cancelling licenses rather than fining people. And cancelling their license, that's a far harsher punishment, to be honest. But I don't think that's what they're going for. I mean, that might happen, but we'll see. But the fact is this could weaken the ability of federal agencies like the National Labour Relations Board, the Federal Trade Commission, the Federal Communications Commission, etc., to enforce fines against those who break laws because they lack the resources to pursue those complaints in federal court. Finally, there is the issue of whether this is a power grab or not. Roberts said this was a power grab by the executive branch. Roberts said the dissent would permit Congress to concentrate the roles of prosecutor, judge, and jury in the hands of the executive branch. That's the very opposite of the separation of powers that the Constitution demands. Sotomayor in the dissent said he's got the wrong way round. It's the courts grabbing the power here. Sotomayor said, make no mistake, today's decision is a power grab. Once again, the majority arrogates Congress's policy-making role to itself. It prescribes artificial constraints on what modern-day adaptable governance must look like in telling Congress that it cannot entrust certain public rights matters to the executive because it must bring them first into the judiciary's province. The majority oversteps its role and encroaches on Congress's constitutional authority. So, whoever you go with, I mean, I'm with the majority on this one, but whoever you go with, there is a potential problem in making it harder for agencies to find the resources to charge people when they breach regulations. Sometimes that you're protecting the little guy if you make it hard for the agency to charge them. Sometimes you're protecting fraudsters and shysters and industries and businesses cutting corners. Let's put a pin in that thought. We'll come back to that. We're definitely going to come back to that thought. Let's go to the next case, which is the big one. Loper Bright Enterprises versus Raimondo. This was also, by the way, decided along partisan lines. Not a coincidence. 6-3. I'll have a little drink and then we'll have the facts. Federal law requires commercial fishing boats to include a trained observer to stop overfishing. The law specifically cites certain classes of boats that are supposed to pay the cost for their own monitors. It mentions a whole bunch of boats specifically in the regulation. Sorry, in the law. One of the boats it doesn't mention in the law is herring boats. So, in 2020, when budgets were tight, the Trump administration's National Marine Fisheries Service created a new regulation which forced herring boats to pay as well, to the tune of $700 a day. This was not mentioned in the law. They read between the lines and said that the purpose of this law would allow this to happen, and so they did that. The herring boat operators sued. They said the National Marine Fisheries Service exceeded their authority that was stipulated in the law, and the Biden administration responded by backing down. They reversed the regulation on the herring boat operators. They reimbursed the herring boat operators their money, but the case continued on because the case wasn't really about herring boat operators. It was sponsored by people who were trying to tear apart administrative law, and I'll explain why. This could have been quite a simple case, I should say, because they could have just dismissed the case, the court that is, they could have just dismissed the case because it's over. The people got their money back, case over. Or they could have just ruled against the government. They could have said, hey, the law clearly didn't include herring boat operators. You're breaching the law. Stop it, which they already had. Because since they didn't reasonably apply the law, they could have held. Easy, no problems, move on. But the court, just like the herring boat operators, were quite interested in unstitching this part of the law. So they kept on going. They exploited this case, essentially, to deal with some unfinished business. Let me explain now the big thing they were trying to unstitch. It's something called Chevron. Chevron deference, which is a doctrine that's been around since 1984 that conservatives, even though it was created by conservatives, like Scalia was a big fan of it, even though this actually came into being just before Scalia rose to the Supreme Court. He was a big fan of the Chevron deference concept. But now conservatives aren't such a fans of it. It's a two-step process, the Chevron deference. Number one, you ask, is the statute clear in its intention? If the statute's clear in its intention, you follow the statute. If they don't follow the statute, they're breaching the law. Simple. Two, if it's not clear and the agency has interpreted the statute as they will, is their interpretation reasonable? If it's not reasonable, then they're breaching the law. Regulation is cancelled, right? Overturned, struck down. But if it is reasonable, then you respect the agency's judgment as the court. If the court feels they're not being reasonable, they overrule them. If they are reasonable, then whatever the agency said, you go with. That is Chevron deference. What's the problem with Chevron deference? Broadly speaking, Clarence Thomas noted that Chevron compromises the separation of powers. He said, quote, it curbs the judicial power afforded to courts and simultaneously expands agencies' executive power beyond their constitutional limits. Theoretically, I see that because the court is meant to be the ones who are interpreting the law, not the executive. That's not the executive's job. So I see his point. What does precedent say? Well, Roberts cited, he wrote the majority again. Section 706 of the Administrative Procedure Act. It tells federal courts, quote, to decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of an agency action. Roberts said, the APA thus codifies for agency cases the unremarkable yet elemental proposition reflected by judicial practice dating back to Marbury, that's a long time ago, that courts decide legal questions by applying their own judgment. It specifies that courts, not agencies, will decide all relevant questions of law arising on review of agency action, even those involving ambiguous laws. Whereas Chevron requires a court to ignore, not follow, the reading the court would have reached had it exercised independent judgment as required by the APA. So he says the APA makes it very clear that Chevron deference is against the law. What does the dissent say? The dissent was written by Elena Kagan. She said that law was written 80 years ago. They had no idea about Chevron deference then. It wasn't going to be around for 50 more years. Furthermore, Kagan said that Roberts' precedent statute didn't actually contradict Chevron anyway. She noted that a deferential standard doesn't remove courts' judgment. It's an interpretive tool that courts can use when exercising their independent judgment. Now, they might choose to follow what the agency said, but they might believe the agency was unreasonable. That's what Chevron is. Chevron says if the agency's unreasonable, then you don't follow it. So the court is exercising their judgment. Are they being reasonable or not? So she says that your precious precedent, John Roberts, actually supports us. Chevron deference is consistent with the APA. She also noted that at the time that the APA came into being, judges tended to use deference to the agencies anyway, because the agency had experts, The judges, they didn't know what they were doing with all these technical stuff. So the agencies would come in with their experts, they'd say what their research showed, and the judges would usually listen to them. And that happened both before and after the APA. So she said, no one at the time interpreted this law in the way that suggests you shouldn't show deference to the agencies. So what's wrong with that? Like, you, Mr. Originalist, why don't you look at how they treated this law when it came out? Kagan said, quote, the majority's whole argument for overturning Chevron relies on Section 706 of the APA, but the text of Section 706 does not support that result, and neither does the contemporaneous practice, which that text was supposed to reflect. So today's decision has no basis in the only law the majority deems relevant. It's grounded on air. She has a way of words, does Elena Kagan. Kagan then went on to say, this is just a power grab. Remember I told you we'd keep on coming back to these concepts. All these cases are related. She said, in one fell swoop, the majority today gives itself exclusive power over every open issue, no matter how expertise-driven or policy-laden, involving the meaning of regulatory law, what actions can be taken to address climate change or other environmental challenges, what will the nation's healthcare system look like in the coming decades, or the financial or transportation systems, what rules are going to constrain the development of AI. In every sphere of current or future federal regulation, expect courts from now on to play a commanding role. Now, she thought that was a real problem. The majority said, yeah, duh, that's their job. Roberts said, the basic nature and meaning of a statute does not change when an agency happens to be involved, nor does it change just because the agency has happened to offer its interpretation. The statute still has a best meaning, necessarily discernible by a court deploying its full interpretive toolkit. In other words, let them do their job. He also said other statutes are often ambiguous. And guess what? The courts interpret them just fine. What's different? If there's an agency involved. It's the job of a court to interpret a statute. They can take notice of an agency's interpretation if they choose to, or they cannot, but it's up to them to decide, not to get the agency to do their job for them. Importantly, Roberts dealt with a whole issue that the dissent was running with, which was, you're going to turn all the current regulations into chaos. The last 40 years of regulations have been based on Chevron Chevron deference. Are you going to turn them all upside down? Are they all going to get re-regulated in court, reheard? This is going to be chaos. Roberts just short-circuited that whole line. He said, nah. We're going to minimize disruption. Quote, we do not call into question prior cases that relied on the Chevron framework. The holdings of those cases that specify agency actions are lawful are still subject to statutory stare decisis despite our change in interpretive methodology. He said all of them are precedents, they're holding. We're from now on changing our interpretive methodology. We're not going to go back and re-examine those cases. So that's good. At the very least, it's not going to turn the whole system into chaos. So that's good. Finally, Gorsuch added in his concurrence that Chevron was wildly impractical. He said it leads to flip-flopping interpretations between administrations because different administrations have different partisan views and they interpret regulations in different ways. He gave an example. Actually, this was a Clarence Thomas case from a while back. Brand X concerned a law regulating broadband internet services. There, the court upheld an agency rule adopted by the administration of President George W. Bush because it was premised on a reasonable interpretation of the statute. Later, President Barack Obama's administration rescinded the rule and replaced it with another one. Later still, during President Donald Trump's administration, officials replaced that rule with a different one. All before President Joe Biden's administration declared its intention to reverse course for yet a fourth time. Each time, the government claimed its new rule was just as reasonable as the last. Rather than promoting reliance by fixing the meaning of the law, Chevron deference engenders constant uncertainty and convulsive change, even when the statute at issue itself remains unchanged. So, Who should deal with all these complicated regulations, though? This is the Kagan point. Some of these regulations are endlessly technical. So, like, for instance, is there effective competition between cable TV providers and streaming video providers in Kauai, Hawaii? Does the process of mixing and bagging sand constitute milling, which is regulated under the Mine Safety and Health Act, or is it manufacturing, which is regulated under the Occupational Safety and Health Act? Kagan says that courts are going to struggle with, those are real questions, by the way, in actual cases. Kagan says that courts will struggle through trying to referee areas they don't understand. Roberts and Gorsuch, though, said courts have all the tools to interpret laws. They do it all the time. It's no different if the laws involve regulations and technical regulations. Gorsuch also said that the dissent was engaged in ridiculous doom-mongering. Gorsuch: the nation managed to live with busy executive agencies of all sorts long before the Chevron revolution began to take shape in the mid-1980s. And he's right. The administrative state was massive and complex even before Chevron. Chevron's not required for that to happen. Gorsuch said, this ain't about technical expertise, this is about power imbalances. This is from his concurrence. Sophisticated entities and their lawyers may be able to keep pace with rule changes affecting their rights and responsibilities. They can lobby for reasonable agency interpretations and even capture the agencies that issue them. By contrast, ordinary people can do none of those things. They're the ones who suffer the worst kind of regulatory whiplash when the law changes according to bureaucratic whims. Gorsuch, for example, cited cases involving a veteran seeking disability benefits, where the veteran lost 3 years of disability benefits because of an arbitrary rule. He cited a number of little guy situations. He said the little guy doesn't have the power to take on an agency, but the court can. Sometimes he's right. Sometimes going to the court is better for the little guy, no doubt. But practically speaking, will this make a difference? Theoretically, it might not make a huge amount of difference, to be honest. Chevron is already effectively dead. It's been gradually phased out for 10 years. For example, the aficionados of the Supreme Court will be aware of the major questions doctrine that came in recently, where questions of major economic and political significance were already not covered under Chevron deference. The agencies weren't allowed to freelance on questions of major economic and political significance. As Roberts put it, the Supreme Court had previously issued a series of decisions significantly limiting Chevron, creating a Byzantine set of preconditions and exceptions. He said, this has only added to Chevron's unworkability, transforming the original two-step into a dizzying breakdance. In fact, Chevron hasn't been used by the Supreme Court at all since 2016. Roberts said, at this point, all that remains of Chevron is a decaying husk with bold pretensions. Also, some states got rid of Chevron ages ago. Some states have never had Chevron. And the states that have abolished Chevron like judicial deference or never had it in the first place, their executive agencies aren't any weaker than other states' agencies. So it's certainly not significantly weaker or have significantly lower levels of regulation. They still find a way to regulate. Also, Roberts did actively try to minimize disruption, like I said, respecting all the precedents in the past. So that theoretically shouldn't make much of a difference. The decisions have already been made. Going forward, Congress will write statutes differently, knowing now how they're going to be interpreted by courts, won't they? So they'll adjust, theoretically. Agencies only need to step in when the statutes aren't clear. So now, if you don't want the court to interpret them, just make the statute clearer from now on. Also, agencies are still going to be involved. It's not like they're being fenced out or anything. If the agencies have expertise in relevant questions, they can still share the expertise with the courts. No one's stopping them. The courts are supposed to pay their views respect. They're actually meant to, just not deference. There's a difference between respect and deference. There are many statutes where Congress gives agencies specific delegated authority to make calls as well. Those ones won't be affected because the statute says that agency makes that call. So then the agency makes the call. The court will respect that authority. You could say they'll be deferent to that authority. The issue here is only about statutes that fall in the gaps. They're uncertain about what the powers of the agency are. Finally, be careful what you wish for if you want to get the agencies, because to the extent that it might make a difference, this could hurt the right more than the left. The left have had their go in the agencies for the last X years. They've been at it for some time. It's just in the last couple of years that the right have started to say, hang on, we'll have a go at those agencies, please. Project 2025 that people talk about so much is all about taking over the agencies and passing a bunch of right-wing regulations. That's what Project 2025 is. Chevron, getting rid of Chevron can completely stuff up a lot of Project 2025, at least the bits that are involving the agencies. So all the left's decisions have now been covered by stare decisis, like precedent, at least according to Roberts. But if the right want to clear out the agencies and start again, like they're threatening to, their rulings will be the first ones affected by this decision, Loper Bright. So what goes around comes around a little bit for the right and left on this issue. Bottom line for me, this rule, the getting rid of Chevron, Loper Bright, it actually makes sense to me. I understand where they're coming from. But once again, it's just one more reason why it's harder for agencies to pass and enforce regulations. Now, when they enforce a regulation, they've got to be concerned, are we going to get taken out by Loper Bright? Is some judge, freelancing judge, going to say, you know what? I don't have to have deference to you anymore. I'm striking your whole regulation down. So they're taking a risk every time they enforce a regulation. They know where they're going to get sued. They're going to get sued in the Fifth Circuit. But they know how this works. They're going to get some super conservative judge. And then it's going to get appealed to the Fifth Circuit, who are all super conservative. And then it may go to the Supreme Court. So it's a long road until you get to the Supreme Court. An agency might not want to go through all that. So this is going to discourage agencies from enforcing actions, potentially. So there's one more way that agencies are discouraged from enforcing regulations. That's Loper Bright. Case number 3. Have another swig of water. Ohio versus EPA. Now this time, it's not 6-3, it's 5-4. The 5 most conservative justices versus the Liberals plus Amy Coney Barrett. Amy Coney Barrett is always, there's always a chance she's not going to be with the other 5 conservative justices, as we've discussed a few times. And this is one of those examples. This is about something called the Good Neighbor Rule. The Good Neighbor Rule requires the states limit their emissions to offset the effects in states downwind of their pollution. It's trying to protect states that are downwind of pollution from your emissions. This rule was issued in response to states not reducing ozone pollution after they were specifically instructed to in 2015 under the Clean Air Act. They kind of ignored that. 23 states either didn't submit any plans to reduce ozone pollution, or they submitted plans that didn't meet EPA standards, and they were found to have significantly contributed to ozone pollution in downwind states. The EPA is statutorily required to ensure states comply with federal air quality standards. That's their job that the law has given to them. And to create a federal implementation plan if the states don't comply. So the EPA wasn't freelancing here. They were doing exactly what they were told to do by the law. The result was the Good Neighbor Plan. What's the problem with this? States complained that the rule would cause irreparable harm and they sought a stay. They got that stay, and then the court upheld the stay 5-4. Kavanagh was the writer of the majority in this case. He said it was too difficult to implement because who would be affected changed with the winds. When the winds blew one direction, there'll be some states affected. When it blew in a different direction, other states would be affected. That's too confusing. He said the EPA failed to explain how it would modify the rule's application if states initially subjected to the rule dropped out. Gorsuch said that this issue had been flagged in the comment period, but the EPA did not do enough to address that comment. They said the EPA had a procedural failing. They should have had a much better explanation in response to the relevant comment. It wasn't because of the substance of the rule that the stay was. The stay was fine with the rule. The court was fine with the rule. That wasn't for the reason for the stay. The reason for the stay was because they didn't address that comment. That single comment. Now, to be clear, the EPA received quite a few comments. They received 1,100 highly technical comments, none of which targeted this concern. And yet, the agency did actually address the concern. That was kind of half addressed, raised by one comment. They just didn't address it in the depth that the Supreme Court felt they should. So you got 1,100 comments and the state and the agency's trying to address them all. If they don't address it perfectly the way the Supreme Court wants them to address it, sorry, that regulation is not going to be enforced. Now, Amy Coney Barrett dissented from this. She wrote the dissent. She said the EPA was being deprived of enforcing a lawful regulation due to an overly technical application of administrative law. She said, while the court suggests that the EPA failed to explain itself sufficiently in response to comments, this theory must surmount sizable procedural obstacles and contrary record evidence. Applicants therefore cannot satisfy the stringent conditions for relief in this posture. Now, there are two main issues here. One is Barrett hates stays. Generally speaking, Amy Coney Barrett generally is looking for an excuse to not give a stay. Some of the other cases which I haven't mentioned and may not mention, she's also come out against stays unless they meet a really high standard. She seems to hate issuing stays. She reiterated a test that we're going to be seeing a lot in other cases. She said, to obtain emergency relief, applicants must, at a minimum, show that they are likely to succeed on the merits, that they will be irreparably injured absent a stay, and the balance of the equities favours them. Now, that's a high standard to meet for a stay, much higher than the other justices have. But over time, she's beginning to pull the rest of the court towards her. She is single-handedly discouraging judicial activism by making it really hard to get a stay, which is an interesting development that I don't think people saw coming when they appointed her. It's one of a number of interesting developments with Amy Coney Barrett. In this case, I'd say she's right. I'd say they are being overly technical. I'd say they've been ridiculous. And I think that her standards have not been met by the people seeking a stay, and I think her standards are great. Barrett noted that as well, that the EPA probably wouldn't have changed anything about the rule, even if they had addressed the challenger's concerns more thoroughly. They would have just blown them off in a more effective fashion, but they wouldn't have changed the rule. So it's completely academic, the reasons behind this stay. She also said that the Clean Air Act contains a harmless error rule that instructs courts not to invalidate a regulation due to procedural errors, unless, quote, the errors were so serious and related to matters of such central relevance to the rule that there's a substantial likelihood that the rule will have been significantly changed if such errors had not been made, which she just showed would not have been the case here. They wouldn't have changed the rule. So the Clean Air Act, as a statute, explicitly says that their harmless error shouldn't be held against them. So I am 100% with her on this one. I think her rule, her dissent is perfect. This stay would not succeed on the merits. They should not have issued it, in my view. But then there's more. Agencies are increasingly under the pump. Barrett, one of the Conservatives who was on the side of the other two cases we just talked about, expressed concerns about agencies having to respond perfectly to every single comment. She said doing so risks the sort of unwarranted judicial examination of perceived procedural shortcomings that would make it impossible for agencies to do their jobs. And you know what? That was a surprise to hear, because the Conservatives usually are quite unsympathetic to those kinds of arguments from agencies. But she's right. It's a thing. There was a 1974 paper, Why the Haves Come Out Ahead, which showed that litigation favours repeat players because the courts are reactive. So if you hassle the courts enough, eventually you'll get your way. One of your cases is going to come up, and you'll come up with trumps eventually. So how do you hassle them a lot? You need a lot of resources. The more resources you have, the more you can hassle them, the more success you have. You need resources, you need information, you need money. You know who has them? Industry, not the little guy. So one study examined 40 rules across 4 agencies, and they found that business interests submitted 9 times as many comments as did public interest groups. They were higher quality comments as well. They were longer, they were more technical, they were harder to answer. Another study of 90 EPA rules found industry submitted 81% of all the comments. Public interest groups submitted 4%. And the EPA's rules were more apt to be weakened as the number of comments increased. Another study of hazardous waste rules at EPA over a 3-year period found that industry groups submitted 30 times more comments than public interest groups. There's no contest. The industry groups have the money. They have the expertise. They're coming up against volunteers usually. Of course, they're going to be able to dwarf what the volunteers can do. So they're going to have more success. It's an arms race where it's nuclear weapons against pea shooters. And it's not just quantity. As I said, it's about complication as well. There's no maximum length, no maximum volume of comments. So if an industry group bombs an agency with thousands of pages of comments full of technical information, they can bury that agency in procedural requirements. And it just takes one comment that you didn't answer properly for them to get a stay from these conservative judges. If you just draw one idiot judge who thinks a comment is particularly important at district court level, you're on the path to the Supreme Court. Off we go. Huge amounts of expense, huge amounts of time, huge amounts of resources. So once again, there's an incentive for agencies to not enforce regulations, because if they do, they might get done by a comment. Do you think I'm maybe exaggerating about the fact that judges might not know what they're doing here? Well, let me quote Neil Gorsuch. Neil Gorsuch, in his majority ruling, mistakenly referred to nitrous oxide instead of nitrogen oxide 5 times. Nitrous oxide is laughing gas. Nitrogen oxide is air pollution. He didn't know the difference. Neither did any of his clerks or anyone else on the court who didn't correct them while that ruling was just sitting around for ages before it was published. That was super sloppy. And yet he's the one who's telling the EPA that comment is super important. They should really be paying attention to that comment, like he has a clue. This was actually the point made by the dissent in Chevron about judges pretending they're experts when they're not. So here's another case where the same kind of arguments are being made. What about the comment in this case, though? I've been talking generally. Guess who wrote the comment in this case? It was the Air Stewardship Coalition, which is an industry front group for the American Petroleum Institute, ExxonMobil, and the National Association of Manufacturers, amongst other companies. These guys, surprise, surprise, wanted to fight pollution emission restrictions. And they succeeded, thanks to this principle. Now, of course, agencies are aware of this. They know who's going to be suing them. They know it'll be industries, not public interest groups. So they pour resources into addressing these complaints. They try to address it. But basically, in conclusion, these cases, they won't always help dodgy businesses. Sometimes they'll help out unions. Sometimes they help out environmentalists. Sometimes they help out the little guy being pushed around by bureaucrats. Yeah, sometimes these kinds of concerns are really good. Like they help the right people. But you know what? If you're playing numbers game, they usually don't. And if you're an agency, why would you enforce a regulation if you know you have to take on the risk and the resources of a jury trial to enforce it because of Jarkesy? Why would you do it if you know that if you do enforce a regulation, the judge will give you no deference? They'll just second guess you. Who knows how the judge, probably conservative judge, might, because they'll be judge shopped, so it'll be a conservative judge. Who knows how the judge might interpret the law on that day? Who knows? And why would an agency enforce a regulation when they know the judge might strike their regulation down because they didn't batten down every single bad faith comment from professional, brilliant trolls? Also remember, every single challenge is coming through, like I said, the Fifth Circuit, the most conservative judge they can possibly find, probably. So it has maximum chance of being struck down. All incentives point to enforcing regulations less often and only in surefire cases. This is the concern. Even if you agree with each of these individual rulings with the majority, they add up. Every single one builds on the one before to make it so much less worth it for an agency to enforce a regulation. As it turns out, I agree with the first two. I don't agree with the third one. I'm with Amy Coney Barrett on this one. In fact, I'm with her in all three. So basically, all these cases work together to create the potential for impunity for bad actors. And here's the key. Even though they're going to bust a couple of these bad actors as they go along, it will, number one, only be the surefire regulations that they will try to enforce, because they'll be scared of regulations being struck down. But also, businesses are going to know what's going on. They're going to see that there's more impunity going on. And so they're going to start acting like they have impunity. As soon as you start letting people through the gates, more people push through the gates. It becomes a cycle. And so this is the beginning of a non-virtuous cycle, potentially, encouraging further and further impunity from industry. That is the concern. And you know what? It ain't an accident. It's not a coincidence that of all the things that these judges disagree on, and there's a lot, these conservatives like Neil Gorsuch, all about busting big government. Like, he likes small government, he likes individuals. Brett Kavanaugh is all about big government. He loves big government. Amy Coney Barrett is completely different to all of them. Alito is MAGA boy. Thomas is Mr. Originalism. They've all got different specialties and different interests and different strengths and weaknesses. But there's one thing that joins them all together, especially the five most conservative ones, and that is hostility to federal agencies. That's not a coincidence. White House counsel Don McGahn made hostility to the administrative state a litmus test for Trump's judges. He admits it. He openly admits that he's the one who selected them, by the way, not Trump. He openly admits that when he recommended a judge to Trump, his key priority was hostility to the agencies. Don McGahn said, quote, "None of this was an accident. It was a way to corral the runaway bureaucracy to get judges in place who are actually going to read the law as it was written," he said. Mitch McConnell said, "Dismantling the administrative state and empowering people who are actually elected to make decisions has been the motivating force for nearly every Federalist Society type lawyer. I think the left thought that all we ever talked about was Roe versus Wade. Frankly, I can't even remember it coming up. This was the unifying issue," he says about administrative law. And now we're seeing the effects. By the way, the only judge who wasn't properly vetted because it was a big rush at the end and they weren't expecting the vacancy was, of course, Amy Coney Barrett, because she was chosen after Ruth Bader Ginsburg untimely died. They weren't expecting a vacancy then, so they didn't spend months going through their records to vet them. The election was coming up. There wasn't much time left. And so they rushed her pick. She has no record. They couldn't vet her properly. And that might be the reason why Amy Coney Barrett is such an interesting judge, because they didn't get the opportunity to pick a Stepford judge like they wanted. And so they might have made a mistake on a number of levels. I mean, look, she's still on their side for a lot of this administrative stuff, but she was the leading dissent on Ohio, so she's not quite on board with the other guys quite as much. Having said that, there's one more case. She was with the other guys. 6-3, party lines again. It's amazing how all these are party lines, at least largely. Corner post. This is the final case. I'm not going to go into too much detail on this one because it's not relevant. It was about the statute of limitations for a complaint against an agency regulation. The default is 6 years for the statute of limitations. But when do you start the clock of the statute of limitations? Section 2401A says, suits shall be barred unless the complaint is filed within 6 years after the right of action first accrues. What does that mean? After the right of action first accrues. The Conservative majority say that this clearly means the clock begins when an injury has been suffered, when the right of action first accrues, when you suffer an injury. They said Section 2401A's text focuses on a specific plaintiff when it says the complaint is filed within 6 years after the plaintiff's right of action first accrues. The dissent said this clearly means the clock begins when an injury is sufferable. Section 2401A does not say the clock starts when the plaintiff's right of action first accrues. It starts the clock when the general right of action first accrues. That's what they said. Honestly, it could mean either. It's ambiguous. They both have a point. I don't know what you think. My view is I would say when a law is unclear, you should go with the fact that the courts have interpreted this the dissent's way for the last 75 years. There's a very clear precedent. It's with the defense, with the dissent. So, until now, they've always interpreted the statute of limitations as from when the regulation first goes into effect, not when the injury first accrues. Amy Coney Barrett wrote the majority, and they decided that they'd just change everything. Sorry, Amy, I'm not with you on this one. This seems not very originalist to me, I have to say. Ignoring all precedent. Why? Just cause. Why do we care? Why does this matter? Seems very technical, doesn't it? Let's go to the dissent that was written by Judge Jackson, Ketanji Brown Jackson. She makes the point that all you need to do now is to create a new fake entity that's supposedly injured by a regulation, and you can take down any regulation, even ones that have been around for 100 years. And this kind of legal astroturfing, that's par for the course. Like the mifepristone case just this year. Remember the one about the Alliance for Hippocratic Medicine, or whatever it was called? There was an obvious front for pro-life people, pro-life activists. They found like 3 doctors who agreed with them, create a new group and said, "Oh, we've been affected by this regulation," and they took it all the way to the Supreme Court. Jackson said, "Oh, by the way, they're now going to be able to challenge the original approval of mifepristone because of this. Because in the mifepristone case, they could only challenge the most recent regulations with mifepristone because of the 6-year statute of limitations. But now they can go back more than 6 years because they can just create a new action by creating a new front group that's just been injured. And they can go back to the original approval of mifepristone like a few decades ago. So that's what they're going to do, for sure. They'll go back and they'll try and knock out mifepristone entirely rather than just the latest iteration of approval. So that's the way this ruling is going to work. It's going to encourage this kind of activism. Judge Jackson says, any established government regulation about any issue, say workplace safety, toxic waste, consumer protection, can now be attacked by any new regulated entity within 6 years of the entity's formation. A brand new entity could pop up and challenge a regulation that's decades old, no matter how entrenched, heavily relied upon, or central to the functioning of our society a rule is. The majority has announced open season. And she referred obliquely to the Loper Bright decision that we just discussed. The discerning reader will know that the court has handed down other decisions this term that likewise invite and enable a wave of regulatory challenges, decisions that carry with them the possibility that well-established agency rules will be upended in ways that were previously unimaginable. Doctrines that were once settled are now unsettled, and claims that lacked merit a year ago are suddenly up for grabs. So now, and I'm very much on her side of this one, so now add to this the list of changes from before. Not only has the Conservative majority on the court, minus ACB on one case, made it way harder for agencies to defend regulations, way easier for industry groups to attack regulations, but they've also given industry groups unlimited shots at doing so. They can try over and over again with a new group, and then another new group, and then another new group. They can do this forever. The court has potentially changed the balance of power in American governance completely. We have no idea what this is going to look like going forward. We have no idea. Like, you would think conservatives would be worried about laying change upon change upon change upon change all in at the same time, because you don't know the effects the unintended consequences of what you're doing. But this is what they've done. So we'll see where this takes us as far as the agencies go. God knows. Maybe it'll have no effect at all. Maybe it will have a massive effect. As an aside, by the way, I actually agree that a lot of these, like I've said, a lot of these changes do make better due process. And, that's good. But the question is, from a broader point of view, why is the administrative state so all-encompassing? Why are the Conservatives so hell-bent on pruning the administrative state? Because look, they're not delusional. It's right. They're right. The administrative state is large. It is overwhelming. Why are these agencies so overwhelming? Have a look what just happened with Biden, with his student debt reforms. They're all through agencies. Why didn't he just pass it through Congress? We know why. Because Congress doesn't do anything. That's why. I mean, look, the student debt might have not gotten through anyway, but just generally, Congress doesn't pass laws anymore. So the agencies are filling the space. That's the story of the last 20 years. While Congress has become more and more performative and less doing its job, there's a vacuum formed and the agencies have filled the vacuum. That's what's going on. If you pare back the agencies and Congress doesn't become more effective, there's going to be a hole where that regulation should be. There'll be another vacuum. To give you an example I'm talking about, remember my stats nugget a while back about IVF, about how there is no regulation about IVF. None. You can go full Gattaca if you want. You can create perfect test tube babies if you want. You can select for any quality you like. Height, race, intelligence, immunity, whatever. You can go nuts. Create your perfect test tube baby because there's no regulation. There is a gap where it should be. There are gaps everywhere in America where regulations should be. Sometimes the agencies fill those gaps. Sometimes there isn't an agency to fill that gap. AI is an example right now where they're trying to work out what they're doing. Congress needs to be fixed so that it does its job. Because if you do what the Supreme Court's doing right now and you pare back the agencies and Congress doesn't do its job, the vacuum will be back. And you know what? Something will fill it. You can be sure. That's the laws of both real physics and parliamentary physics. When a powerful enough vacuum is formed, something is going to fill it. And you might not like what that is. We don't know what it is yet, but it's going to be something. So please, Congress, start doing your job, and then none of these rulings will be a problem at all. It just takes Congress doing its job. Okay, that's the end of section 1. I'm going to fire up a white flash. I'm going to drink a lot. I'm going to check my export of PEP 166, and then we can get back into part 2. That was an hour 5, so I guess we're going to end up about 2 hours. That's not bad. Yeah, a nice short one, kind of. I'll see you after the white flash. Welcome to part 2 of this very special Supreme Court focused podcast. You might call it a Chaz Unleashed podcast. I had to slip that in the first part because I forgot to say it, but I haven't forgotten this time. Let's get into part 2. We're talking about Trump's trials. There are 2 cases that are relevant to Trump's trials. The first one is Fischer. This was a 6-3 ruling, but not a partisan ruling. It was the usual conservative 5 with Ketanji Brown Jackson, which was an interesting change-up. And that was versus Kagan Sotomayor and Amy Coney Barrett. So that was interesting. The facts are that Fischer is a bad dude. Fischer has been charged with 7 crimes on January 6, including assaulting a federal officer and impeding a law enforcement officer during a civil disorder. But one of the things Fischer was charged with was violating Section 1512C, which is interfering with an official proceeding. What does that mean? Section 1512C says, whoever corruptly, 1, alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in any official proceeding, or 2, otherwise obstructs, influences, or impedes an official proceeding or attempts to do so, shall be fined under this title or imprisoned not more than 20 years or both. First part, crystal clear. You can't alter, destroy, mutilate, or conceal a record or document. You can't mess with evidence. Simple. The second part, not so clear. Or otherwise obstructs, influences, or impedes any official proceeding or attempts to do so. What does otherwise mean? Does otherwise mean in some other similar way to the first part about messing with evidence? So it means otherwise messing with evidence? Or does it mean otherwise in some quite different way? So talking about anything whatsoever, any interference of any kind with an official proceeding. What does that mean? The majority was written by John Roberts. He said means in a similar way. Roberts, there were many analogies drawn during this case. This is the one I like the best. A zoo might post a sign that reads, "Do not pet, feed, yell, or throw objects at the animals or otherwise disturb them. If a visitor eats lunch in front of a hungry gorilla or talks to a friend near its enclosure, has he obeyed the regulation? Surely, yes. Although the smell of human food or the sound of voices may well disturb gorillas, the specific examples of impermissible conduct all involve direct interaction with and harassment of the zoo animals. Merely eating or talking is so unlike the examples that the zoo provided that it would be implausible to assume those activities were prohibited, even if literally covered by the language." This argument does make sense in a logical way. Otherwise, in a list, does usually have a completely that does not usually have a completely open-ended meaning unconnected to the rest of the list. It usually is related to the rest of the list, isn't it? Roberts also considered the effect of C2 on C1. Roberts noted, if you read the second part so broadly that it included all activity interfering with official proceedings, then that would include the entire first part about interfering with evidence at official proceedings. So why did they even bother writing the first part? Roberts, quote, guided by the basic logic that Congress would not go to the trouble of spelling out the list in C1 if a neighbouring term swallowed it up, the most sensible inference is that the scope of C2 is defined by reference to C1. That's quite an elegant argument, I think, to be honest. Just to make sure you're following that, he's saying if C1 was for a little bit, for the evidence section, but C2 meant for everything, then you'd never write C1. It suggests they didn't mean C2 to swallow up everything. They meant it to be more particular. Roberts also cited a precedent. Yates versus United States, 2015. The law in Yates targeted anyone who knowingly alters, destroys, mutilates, conceals, covers up, falsifies, or makes a false entry in any record, document, or tangible object with the intent to obstruct a federal investigation or proceeding. Now, a commercial fisherman caught undersized fish. Then he tossed them overboard to prevent federal authorities from confirming he'd harvested undersized fish. The court decided the undersized fish are not a tangible object within the meaning of the law. Ruth Bader Ginsburg held that the court should avoid ascribing to one word a meaning so broad that it is inconsistent with its accompanying words. And thus, the term tangible object should be read to refer not to any tangible object, but specifically to the subset of tangible objects involving records and documents. You can see how that precedent would apply in this case. That logic applies. Cool. Finally, Roberts was concerned about the practical effect of this use of the law. He's worried that the same law could be used to outlaw peaceful protesters and other First Amendment protected activity that was interfering with an official proceeding. Remember, in that list of verbs, it had the word influences. It bans influencing an official proceeding or attempting to do so. That's just protesting. That's not even disrupting it. That's just influencing. So that was his concern. If you interpret it that broadly, it will encompass all kinds of stuff that you don't want it to encompass. Now, Jackson, Ketanji Brown Jackson was a public defender. So she's often thinking about the defendant and from the defendant's point of view. And her concurrence notes the context of the law as well. She noted the statute came from the Sarbanes-Oxley Act of 2002. It was written in response to Arthur Anderson destroying documents to help out dodgy corporation Enron. Jackson said, "There's no indication whatsoever that Congress intended to create a sweeping all-purpose obstruction statute." Now, I suppose the rebuttal of that is, would legislators have thought, it's fine to interfere with an official proceeding as long as you use violence rather than shredding documents? That's probably a fair rebuttal. But anyway, the point is, these are all very reasonable arguments, I feel, from the majority who are trying to exclude Fischer from being charged with interference in official proceedings, suggesting that it shouldn't apply to January 6. Let's get to the dissent. Amy Coney Barrett. Her dissent was essentially, she wrote the dissent. Her dissent was essentially, this is all fine. Read the law. It means what it says, Barrett said. The court does textual backflips to find some way, any way, to narrow the reach of a subsection. The court does not dispute that Congress's joint session qualifies as an official proceeding. January 6 was, like the actual procedure, was an official proceeding inside the Senate. That rioters delayed that proceeding, or even that Fischer's alleged conduct was part of a successful effort to forcibly halt the certification of the election results. Giving these premises, the case that Fischer can be tried for obstructing, influencing, or impeding an official proceeding seems open and shut. So why does the court hold otherwise? Because it simply cannot believe that Congress meant what it said. So she's just being a textualist. She's saying, just read it. What it means is very clear, and it very clearly applies to Fischer's case. She said, Section 1512C is a very broad provision, and admittedly, events like January 6th were not its target. But statutes often go further than the problem that inspired them. And under the rules of statutory interpretation, we stick to the text anyway. That's also a very reasonable take, I have to say. And by the way, she came up with some wonderful analogies. Like the zoo one, they went through football analogies. It was great. I don't want to waste your time by going through them all. But if you love analogies, go read their judgments. Oh my God, they're filled with them. Roberts and Barrett went back and forth. It was, you could cut the tension with a knife. Sexual tension I'm talking about here. Oh my God. They loved it. But anyway, it's an awful thought. Why'd they bring that up? My view is that this is obviously outcome-based judging from Roberts. Obviously. Like, Barrett's right about the text. The text is very clear. And Roberts was concerned about the outcome. He's not meant to be an outcome-based judge, by the way. He's meant to be a textualist or an originalist, or looking at the intent, not a consequentialist who's worried about the consequences of a ruling. I should also say there is a rule of lenity, which has kind of gone out of favour recently, but it used to exist, where you're supposed to give benefit to the accused when the law is uncertain if it covers their conduct or not. But the rule of lenity wasn't a big issue in this case. They didn't really discuss it a lot. They mentioned it once or twice, but it wasn't dispositive. My view is that from a purely textualist point of view, Barrett is clearly correct. Even though I thought Roberts was very clever with his arguments. Just 2 weeks ago in the bump stock case, which I talked to you about, the court held that, quote, the statutory text is clear and we must follow it. And they were very sorrowful about it. Remember Alito was saying, I wish we could overrule this, but the text, it tells us what to do. The text, we have to follow the text. Well, if you follow the text here, you can be just as sorrowful and you can dab a handkerchief underneath your eye, but it says what it says. So follow the text. But having said that, I'm not really mad at at Roberts and Gorsuch, because the unforeseen consequences of outlawing protest, it's a legitimate concern in this case. Like, they're right. Barrett said that the requirements of corrupt intent in this legislation would save the protesters. So they're not protesting corruptly. They're not trying to unlawfully disturb the proceedings. They're trying to just exercise their First Amendment rights. So she's saying the protesters would be protected anyway. Also, she said the requirement that the action must be directly directed at a particular proceeding would also protect a lot of innocent parties as well. Someone needs to be trying to disturb the proceeding in order to be found guilty of this crime. So that does narrow it down a lot. I do agree with Amy Coney Barrett in that respect. But regardless, I mean, for me, it's a bit of a 50-50 for the reasons I've just said, although I would go with Amy Coney Barrett on this one. What are the effects of this, though? Are the January 6ers going to get away with it? Because the ruling was that this should not apply, that the interfering with an official proceeding should not apply to January 6th. No, they're not going to get away with it. Sorry, J6ers. There have been 1,417 people charged with J6 offences. 24% of them, 314, were charged with obstruction of an official proceeding. Let's split them up into trials and guilty pleas. Trials, 128 people were found guilty of obstruction of an official proceeding. That's 9% of cases. All 128 people were found guilty of another crime as well. All of them. So no one is getting off scot-free from a trial because of this ruling. Even if you strike off one of the charges, they were convicted of something else as well. But could affect their sentencing, could reduce their sentence, because this was a big sentence. This is potentially up to 20 years. No one was getting 20 years, but some people's sentence might have changed because of this. 88 of the 128, by the way, were found guilty, not just another crime, but another felony. So serious sentences then. That leaves 40 people who are found guilty of one or more misdemeanors. And yes, their sentences probably are going to be reduced. So they'll be reduced, not disappeared, but reduced. So yeah, it's good for them. Still, it's just 40 people. 1,400 were charged, remember? For those who are still waiting trial, there are some, 71 people are still awaiting trial who have been charged with obstruction of an official proceeding. That's 5% of cases. All of them are charged with something else as well. So they're still going to go to court. They may end up with a lesser sentence than they otherwise would have received, but they're still going to court. 38 of those 71 were charged with another felony, 33 charged with misdemeanors. Okay, so 33 of them may have substantially lighter sentences if they're found guilty. All right, how about the guilty pleas? 48 people, 3% of cases, pleaded guilty to obstruction of an official proceeding. Of those 48, 22, 1.5% of cases, pleaded guilty to obstruction of an official proceeding and at least one other crime. 26 people have pled guilty solely for obstruction of an official proceeding. They may well get off entirely. So they're the ones who are best off as a result of this. But there's only 26 people out of 1,400 charged. So not many people. And I say they may get off because their plea deal included the idea that one of the charges could be later vacated. And the agreement stipulated that they could later be charged with another offence that was initially brought against them but was not pursued when the plea deal was put in place. So if they get off that plea deal, they might find themselves charged with something else. So they may get off, they may not. Also, some of them actually can still be charged with Section 1512C, even after this, because after this ruling said, basically, you need to be messing with evidence. But some of them knew that the thing they were trying to prevent was the certification of Biden's electoral certificates. They're documents. They're evidence. If DOJ can prove the given defendant knew the import of those certifications, then that proves they're trying to interfere with documents or evidence, and they might preserve some of their prosecutions. So some people might still keep that prosecution going. All right, so anyway, a few will get off. Many won't. Almost all of them won't. What about Trump? Remember, this is basically about Trump's trials. Well, 2 of his 4 charges were under this act. Robert said, to prove a violation of Section 1512C2, the government must establish that the defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or, as we earlier explained, other things used in the proceeding or attempted to do so. That was a mouthful. I know it's hard to follow. Let me read it one more time, and while I read it, I want you to think about giving Mike Pence the list of fake electors. Think about the fake electors as I read it to you one more time, okay? The government must establish the defendant impaired the availability or integrity for use in an official proceeding of records, documents, objects, or, as we earlier explained, other things used in the proceeding or attempted to do so. He clearly attempted to impair the integrity of the certificate list, for the elector certificates. He clearly was trying to impair their integrity by trying to supplant them with a fake list of electors on the certificate. So, as far as I can see, I don't see how this affects Trump's charges at all. That's Jack Smith's position, and it's my position. I think this makes no difference. I think Trump's still charged with exactly the same stuff after this. That is, of course, until we get to the big one. Trump versus USA, 6-3 along paths and lines. I'd contest that. As you're about to hear, I'm not sure I would call Amy Coney Barrett a concurrence. She's at least halfway between concurrence and dissent, as far as I can say. But they call it 6-3 along paths and lines. Let's get into it. So you all know the punchline here, that Trump is immune for a lot of things. Let's talk about the theory behind this, and let's build it up bit by bit. Roberts was pushing Justice Roberts, who's the one who wrote the majority, pushed a separation of powers justification. He said, under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. What does that even mean? You might be thinking. Let me explain this in English. Essentially what he's saying is, because of separation of powers, you can't have the Congress trying to restrict the executive on what he does with his exclusive powers. If Congress are interfering with his use of his powers, then they are violating the separation of powers doctrine. That's what Roberts is saying. And so he should be immune from laws that try to do that. But right off the bat, there is something funny here. And that is, he's using as his justification nothing from the Constitution itself. That does not come from the Constitution. Separation of powers is a doctrine that has been developed that's not mentioned in the Constitution. So this floating idea of separation of powers is his justification for this idea. So that's the first thing that's a bit funny. Another thing that's a bit funny is it's not Congress trying to stop the executive. It's the executive trying to stop the executive. It's Biden's Department of Justice charging Trump. The Department of Justice is part of the executive. It's the executive charging itself from a previous administration. So there's no separation of powers issues here. It's one power trying to regulate itself. And that's important because it means that when there's a separation of powers issues, there's no incentives for Congress to butt out of the executive, right? Because they might want a power grab. But in the case, and that violates the principles of the Constitution. But in this case, the executive knows that if they go back and prosecute a past executive, then they may be prosecuted themselves by a future executive. So they have every incentive to show restraint. That is why the separation of powers is not necessarily the best argument here. Because the whole concept of the separation of powers, yes, strictly speaking, the executive is using congressional laws to restrict the executive and to prosecute them. But the actual agent here is the executive. And I think that sits uncomfortably in Roberts' judgment. But anyway, there are 3 buckets. This is stuff you probably know about, but I'm going to go through it in detail anyway. Number 1, the president's core powers. Roberts said, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority. What the hell does that mean? He never says. What people have interpreted that to mean is the core powers explicitly granted to the presentation by the Constitution. The examples that are given in the ruling are the power to issue pardons, the power to veto legislation, the power to make appointments, the power to be commander-in-chief. They are all specifically listed in the ruling, but it might be others. We don't know what the hell that means, what a core power is. They don't define it. It's vague. That's poor judicial work. But that's the first bucket. The second bucket is other official acts that aren't in his core powers. Now, these can be charged, but to do so, you have to show that bringing such charges would not threaten the power and functioning of the executive branch. Then finally, there are the unofficial acts. You can go wild with them. If Trump shoots someone on Fifth Avenue, you can charge him with murder. Okay? What he's doing personally has nothing to do with the presidency. If he speeds in his car, just for the hell of it, when he's joyriding, you can charge him. Okay? You can't, but like that's not an official act of the presidency. So they're the 3 buckets. But there is a problem. I mean, there's a lot of problems. But look, we'll get to them. We'll get to them. He hasn't defined core acts. He hasn't really defined official acts very well either. But we'll get to that. Now, there is some precedent. When I ping him on the separation of powers justification, there is some precedent mentioned. In 1870, Congress passed a law to prohibit a president from restoring property rights as part of his pardoning power. In 1872, in United States versus Klein, the Supreme Court ruled that this law infringed upon the president's exercise of his constitutional powers, several of which the court has deemed conclusive and preclusive. That's where Roberts got that phrase from. So the concept of some kind of immunity from laws which mess with their executive power, there's a precedent for that back in 1870. Even though it's not in the Constitution, there's still a precedent. And so I can respect that. And, I think it's not an unreasonable precedent either. I think that it's not unreasonable for the president to not have to look over their shoulder all the time to see they're not breaking a law when they're being the president. You might object to that. I can understand why you would. I will explain to you as we go on why I am with Roberts on that one. Roberts does make a good argument. We'll get to it though. Not there yet. If I was in your position, I'd agree with you. But we'll get there. Why is this necessary? Why can't presidents just be like everyone else? And this is the bit I'm talking about. Roberts's view is that there is always a law that you can use to harass ex-presidents with if you wanted to, that don't apply to normal people. They only apply to presidents. And he brought up a perfect example, which is Section 371, defrauding the United States. If that sounds familiar, that's what Trump's been charged with. The exact law, one of the 4 laws that Trump has been charged with, is the problem law as far as John Roberts goes. This is a very broadly worded law that can cover, quote, any conspiracy for the purpose of impairing, obstructing, or defeating the lawful function of any department of government. He says, since virtually every president is criticized for insufficiently enforcing some aspect of federal law when they use their discretion, an enterprising prosecutor in a new administration may assert that the previous president violated that broad statute. So there's the example of Joe Biden being charged for not enforcing the border as stringently as conservatives say he should. There's always something. There's always something that a president doesn't enforce as stringently as their opponents believe they should. You know, in the case of, say, Obama and Iran, the Iran deal, conservatives might have said, no, you were too soft on Iran, so we're going to charge you under Section 371, defrauding the United States. John Roberts is right. You can be charged under Section 371, no matter who you are, if you're a president, and pretty much only if you're a president. So he's right. That's a problem bit of legislation. I can understand his concern, and I can totally understand his concern that Trump was charged by that. So, I mean, I must admit, when I first saw Section 371 in the list of indictments way back when, like last year, I didn't really understand it. I was a bit confused by it. And I remember telling you guys that I found the charges against Trump a bit weird. I wasn't really leaning one way or another because I was a bit confused by them. I couldn't quite grok how they applied in the real world. Now I've seen how John Roberts is applying them. I'm concerned about that one, I have to say, just like he is. And John Roberts said, the enfeebling of the presidency and our government that would result from such a cycle of factional strife is exactly what the framers intended to avoid. Ignoring those risks, the dissents are instead content to leave the preservation of our system of separated powers up to the good faith of prosecutors. I think he's right again. I think that's true. I think the dissents are happy to leave it up to the good faith of prosecutors. And I think he's right that there's no reason why prosecutors would show that good faith. And Section 371 could be a free-for-all. So my broad take, before we get into some detail, is I think Roberts' concern is a valid one. I think it's spot on. I think the conservatives who say you brought this on yourself are at least partly correct. I think Section 371 was an overreach with Trump. And I think that this is the consequence. In theory, I have no problems at all with the official act / unofficial act distinction, saying that official acts should have a higher standard for prosecution than unofficial acts. The unofficial acts, you should treat presidents just like everyone else. And for official acts, there should be a higher standard. I'm okay with that. Like for exactly the separation of powers types issues. That's okay. I thought that was going to happen. I said that was going to happen to you guys before. And I think it's reasonable. You can't have the president being charged for just doing their job. You just can't. My concern, though, are the details. The devil is very much in the details on what is an official act, what the standard is for prosecution. And don't even get me started on the core powers. Well, you will get me started. It's coming. So yeah, it's the details that bother me. Let's go into the details. Let's start with the first bucket. Pretty simple here. Absolute immunity means absolute immunity. You can't charge them for exercising their powers, no matter how corruptly. The question is simply, is it a core power or is it not? There's no other question. This is critical. The fact there is no other question. Because if we skip ahead to the SEAL Team 6 question, this is it. This is where it comes from. How many times have you heard this talking point in the last week that I'm about to play you from Bill Barr?
The worst example, I think, the one that makes no sense whatsoever, is the idea that he can use SEAL Team 6 to kill a political opponent. The president has the authority to defend the country against foreign enemies, armed conflict, and so forth. He has the authority to direct the justice system against criminals at home. He doesn't have authority to go and assassinate people. So whether he uses the SEAL team or a private hitman, it doesn't matter. It doesn't make it a carrying out of his authority. So all these horror stories really are false.
Now, I'd like to think that what Bill Barr said there is true. He's not the only one who said that. A number of people have said this, that the SEAL Team 6 example does not apply because that is not their power. They don't have the authority to go around assassinating people with SEAL Team 6. That's what they say. But reading what Roberts has said, I just have to disagree. I feel uncomfortable disagreeing with Bill Barr. The man was the Attorney General, but I think he's wrong. Being Commander-in-Chief is a core function. Not only is it specifically cited in the Constitution as a exclusive and preclusive, whatever that phrase is, power to the president, but John Roberts explicitly cites it as a core function. He has said it is a core function, being Commander-in-Chief. Being Commander-in-Chief means you control the army. And when you're taking advantage of your core powers as the president, you are absolutely immune. There are no other questions to ask. Are they using their core power when they order the military to assassinate someone? Yes, their core power is commanding the military. That's it. Immune. You don't go any further. You can't ask, are they doing the right thing with that power? You can't ask, are they using that power corruptly? You can't ask any question to do with how they're using their power. The question is, are they using a core power? If the answer is yes, that's the end of the story. Bill Barr, I just think, is wrong. So that sucks. Number one. Number two, the second bucket is even worse. This is where it gets really complicated. Non-core but official acts that get presumptive immunity. What does official acts mean? Roberts interprets this extremely broadly. He says, the immunity we have recognized extends to the outer perimeter of the president's official responsibilities, covering actions so long as they're not manifestly or palpably beyond his authority. So he basically defines official as anything that's not clearly unofficial. If it's ambiguously unofficial, then that's still official. If you could even construct the vaguest argument that it might be official, then that's official. The only things that are unofficial are the things that are clearly unofficial. That's not many things, but it actually gets worse. Sotomayor, by the way, in her dissent noted, she said how broad it was. She said the majority's dividing line between official and unofficial conduct narrows the conduct considered unofficial almost to a nullity. I agree. But as I said, it gets worse. When deciding whether something is official conduct or not, courts may not inquire into the president's motives. Like I just said with the SEAL Team 6 stuff for the core activity, even for the non-core activity, you're not to inquire into the president's motives. Why not? This is what Roberts said. Such an inquiry would risk exposing even the most obvious instances of official conduct to the judicial examination on the mere allegation of improper purpose, thereby intruding on the Article 2 interests that immunity seeks to protect. Also, he said, nor may courts deem an action unofficial merely because it allegedly violates a generally applicable law. So he's explicitly saying, if you're doing something patently illegal and manifestly corrupt, we can't pay attention to that. I would say if you're doing something patently illegal and manifestly corrupt, you're probably not doing your job as president. You're probably not actually taking part in official conduct. It's the official conduct thing is a pretext to protect you when you're not doing your job. That's what I would say. But Roberts disagrees. He says you cannot question whether when determining if the act is official or not, if it's corrupt. So, see, I'll also say, by the way, that's part of determining if it's official. If they're exercising their power corruptly, that's part of the test, I would have thought. But Roberts said, no, you can't do that. Which, of course, is going to remove even more conduct, and conduct that you really want to regulate, but more conduct from being charged. So there's less and less in the unofficial bucket. I would argue, like sodomite, there's basically nothing in the unofficial bucket when you're finished with all these rules. Also, how can you possibly rebut the presumption of immunity for an official act without exploring the mindset of the president? That's another great question. Anyway, all right, so let's go into this. How do you rebut that presumption generally? The court says that presumptive immunity can be overcome if the government can show that applying a criminal prohibition to that act would pose no danger of intrusion on the authority and functions of the executive branch. In other words, does charging them interfere with them doing their jobs? What does that mean? I don't know what that means. They don't explain it. It could mean anything. That's so vague. There is so much wriggle room there. We simply, it's hard to get too panicky about this ruling because we don't know what all the key terms mean and how they're going to be applied. If someone did turn around and do SEAL Team 6, you can bet your life when it got to the Supreme Court, they would start to colour between the lines a little bit here to remove SEAL Team 6 from considerations because there is so much wriggle room here. They have essentially what this does in this example, rebutting the presumption, defining official acts, defining core acts, is essentially it's saying, hey, come back to us in the future and we'll make our decision when we see what you've done. That's essentially what they're doing. They are passing this off. They're passing this off, to it coming back to them when Trump inevitably appeals the rulings of Judge Chafkin in response to this. So they're giving themselves a second bite at Trump, assuming he doesn't become president and just dispenses of the charges. But if Biden wins, the court has essentially given themselves a second bite here, and they will define their principles a little bit more then. And if Trump does win and disappears, and there's a corrupt president in 10 years' time or in 2 years' time, they will then define it then, depending on how they feel. They are giving themselves maximum discretion. That's not how courts are meant to work, okay? Just so you know. Courts are meant to lay out principles, not meant to just lay out bullshit, posing as principles to give themselves complete power to decide what they want to include and what they don't want to include in the future. But there is also a very important point to be made here about rebutting that presumption. And this comes straight from Sonia Sotomayor. She had a good dissent, but it hasn't gotten as much publicity as it should have. I'm not sure everyone's read her dissent. The concept of this rebuttable presumption comes from precedent. It comes from Nixon v. Fitzgerald, which said, this is another precedent that John Roberts cited. God bless you, John. 2 cases you found for your, as precedent for this monstrosity you came up with. Mr. Originalist. He found 2 cases. This is the second one. Nixon versus Fitzgerald said, a court before exercising jurisdiction must balance the constitutional weight of the interest to be served against the dangers of intrusion on the authority and functions of the executive branch. One of the things to be considered is the public interest in an ongoing criminal prosecution. Now, you might recognize the phrase, against the dangers of intrusion on the authority and functions of the executive branch, because I just read it before. That was a quote from John Roberts' ruling. He quoted Nixon versus Fitzgerald. You might not have recognized the rest because he disappeared it. He only took half the test, not the full test. When he cited his precedent, he cited it incorrectly. If he was a student, he'd get an F. He screwed that up. Now, either he's a moron or he's a terrible judge. And I know which one I'm picking, where he went out of his way to mislead people with this piece of crap ruling where there was the other court case before. One of the only 2 cases he cited incorrectly, and it made all the difference. Let me explain. Roberts says, at a minimum, the president must therefore be immune from prosecution for an official act unless the government can show that applying a criminal prohibition to the act would pose no dangers of intrusion on the authority and functions of the executive branch. That's his conclusion. No dangers. Originally, the precedent said you should balance the constitutional weight of the interest to be served against those dangers. What do they mean by the interest to be served? Unlike Justice Roberts, they said what they meant. They said the public interest in an ongoing criminal prosecution. So, the original test was you weigh the interests of an ongoing criminal prosecution against the dangers of intrusion on the authority and functions of the executive branch. Which one's greater? The one that's greater is where you go. Roberts said, forget the first test about the public interest of criminal prosecution. That doesn't matter. We'll ignore that. Just focus on the dangers. If there's a single danger, you can't do it. There's immunity. So he turned a balancing test into an anything test, which once again makes it pretty much impossible to rebut that presumption, because there's always going to be some half-assed danger of intrusion on the authority and functions of the executive branch. At some point in time, someone's going to make the argument. So it's no test at all. It's essentially removing any chance of rebutting that presumption of official acts. And you know what that creates? That creates your SEAL Team 6 type example. If they didn't have those stupid core powers that in the first bucket, and they just had this test across the board for all the official acts, but they used the original test, the precedent that John Roberts is supposedly quoting, you wouldn't have the SEAL Team 6 problem, because they would say, when you get SEAL Team 6 taking out your opponent, that obviously is not serving the public interest. And obviously there's a public interest in the ongoing criminal prosecution of using SEAL Team 6 to take out your opponent. And all the other examples we've seen about taking bribes for your pardons and this, that, and the other, all the manifest corruption, there's a public interest in criminally prosecuting that, which outweighs the concern about the intruding into the authority and functions of the executive branch. So if he just followed precedent, then there were no problems. There were no nightmare scenarios. He intentionally decided to create those nightmare scenarios by pretending he's following precedent when he wasn't. I hate that. I hate that so much. So, and it's also sneaky as shit as well, by the way. The fact he hid that he wasn't following precedent. Terrible law, intentionally terrible law. Let's move on. How does this affect Trump? Well, let's go to the core powers first. One of the charges against Trump concerns his threats to replace his acting attorney general. If he didn't further investigate Trump's claims of election fraud, they said that was a core power. Roberts said the president's power to remove executive officers of the United States whom he has appointed may not be regulated by Congress or reviewed by the courts. Okay, so that's a core power. You can't touch it. What if the investigations weren't real investigations? What if they were just a pretext? Because they seemed like a pretext. Trump just wanted them to say they were investigating he didn't care if they did investigate. He just wanted them to write a letter and say publicly that they were investigating. He just wanted them declared. Could be shams. Roberts. The indictment's allegations that the requested investigations were shams or proposed for an improper purpose do not divest the president of exclusive authority over the investigative and prosecutorial functions of the Justice Department and its officials, and the president cannot be prosecuted for conduct within his exclusive constitutional authority. Trump is therefore absolutely immune from prosecution for the alleged conduct involving his discussions with Justice Department officials. That's it. They're in black and white. You can do whatever the hell you like, no matter how corrupt you are, no matter how much of a pretext it is, no matter how dodgy it is, no matter how against the public interest it is. It doesn't matter. It's in your core power. You can do it. So I'm sorry, Bill Barr. That's why SEAL Team 6 can take out whoever the hell the president tells them to take out. Because of that. If it's in your core power, you can do what you like. So anyway, that charge is going to be struck. That one to be struck. The rest are in the presumptive immunity zone. Okay, so first of all, pressuring Mike Pence. Roberts has a bit each way here. He speculates that talking to the vice president about confirming the president's nominees and passing laws that align with the president's policies may well be immune. But the vice president's Article 1 responsibility of presiding over the Senate is not an executive branch function. It's a congressional function. So the government may argue that consideration of the president's communications with the vice president concerning the certification proceeding does not pose dangers of intrusions on the authority and functions of the executive branch because it's a different branch. So he's saying maybe the Mike Pence stuff is chargeable, maybe not. We'll find out when they appeal back to the Supreme Court. Pressuring state officials, the fake elector scheme, how about them? Roberts hints that it's not immune. They're not immune. At one point, he said, unlike the allegations describing Trump's communications with the Justice Department and the vice president, these remaining allegations involve Trump's interactions with persons outside the executive branch. State officials, private parties, the general public. Many of the remaining allegations, for instance, cover at great length events arising out of communications that Trump and his co-conspirators initiated with state legislators and election officials in Arizona, Georgia, Michigan, Pennsylvania, and Wisconsin regarding those states' certification of electors. Unlike Trump's alleged interactions with the Justice Department, this alleged conduct cannot be neatly categorized as falling within a particular presidential function. So it sounds like he's saying they might not be official functions. There might be no presumptive immunity. But then he also says the president's broad power to speak on matters of public concern does not exclude his public communications regarding the fairness and integrity of federal elections simply because he's running for re-election. Similarly, the president may speak on and discuss such matters with state officials, even when no specific federal responsibility requires his communication, to encourage them to act in a manner that promotes the president's view of the public good. So in that case, they are covered by presumptive immunity. Are they? Maybe. We'll find out when Trump appeals back to the Supreme Court. Then they'll tell you whether they think they're actually covered or not. In the meantime, we've got no idea. It is interesting, though, that he does say running for re-election is explicitly not official conduct. that does rule out one of Trump's likely defenses. So, I mean, I'll give him that. That's one thing. That's one bit of certainty. Basically, he leaves all of it up to Chafkin, the district court judge. He's sending it back to Chafkin, saying, you decide. You decide what's an official act. You decide if it has presumptive immunity. You decide if that presumptive immunity is defeated. That will then be appealed to the circuit court, and then to us, and then we'll decide. So he's set up a situation which is going to waste probably a year, and probably in a year's time we'll find out if Trump's not president. We'll find out if he's actually going to be charged with anything. And then after that, you can have his trial. So in the best case scenario, there'll be a trial in the back half of 2025. So what he has achieved is he's created an enormous amount of delay, which suits Trump fine. And it means if Trump wins the presidency, he's not going to be held responsible. Right. Now, Amy Coney Barrett explicitly said, we're going to talk a lot about her soon. She explicitly said that she thought that a number of those acts were unofficial. Unlike Roberts, she actually did some ruling, and she said, I think that some of this stuff is actually unofficial. In particular, things involving fake electors and pressuring state officials, she said, should be unofficial, in her view. And by the way, even John Sauer, who was Trump's advocate, his insane advocate we're all scoffing at 6 months ago, even he admitted to Amy Coney Barrett that he thought the fake elector organising were unofficial acts. So he said they're unofficial. Amy Coney Barrett says they're unofficial. Bloody John Roberts does not. John Roberts has gone further than John Sauer, Trump's advocate. Just think about that. And then there's another issue I haven't even mentioned yet, which is even worse. It just gets worse and worse. This hangs over everything. John Roberts said that official conduct can't be used as evidence to prosecute unofficial conduct. Quote, testimony or private records of the president or his advisors probing such conduct may not be admitted as evidence at trial. So John Roberts is now against using the Watergate tapes because they were describing official conduct by his definitions. Nixon would have got away with it under John Roberts's rules. Why? Because if official conduct for which the president is immune may be scrutinised to help secure his conviction, even on charges that purport to be based only on his unofficial conduct, the intended effect of immunity would be defeated. He's really keen on protecting the intended effect of immunity. He cares about that more than everything else on earth, more than the very Constitution, more than anything. He couldn't give a shit about anything as long as the intended effect of immunity is protected. Honestly, this ruling just does my head in. I just don't get this at all. I don't get this evidence thing at all. If he isn't being charged with the immune conduct, and you're just using that conduct as evidence to show the intentionality of the non-immune conduct, what's wrong with that? If you can't use any immune conduct or any official conduct as evidence, then there's no way you're going to be able to prove the state of mind of the unofficial conduct, because a good lawyer in the executive is going to make sure that they cover key evidence with official acts. So, and if you can't pierce the protection of those official acts, you won't be able to find or use that evidence. And then you won't be able to prove the unofficial conduct. It just seems to be designed to make the president immune, even for unofficial conduct. It just, oh God. And by the way, I said this before, let me reiterate. What the hell does this have to do with the Constitution? This evidence shit. What's this got to do with the Constitution? These guys are meant to be originalists. Where is the justification for this? Where's the precedent for this evidence stuff? He just pulled that out of his ass. There was no justification based on precedent, based on the Constitution, based on contemporaneous evidence, based on anything. It's just policy. It's just policy making like he's a politician from the bench. Barrett just flat out dissented with this section, thank God. Not that it matters because they've still got 5-4, even without her. Barrett said, the Constitution does not require blinding juries to the circumstances surrounding conduct for which presidents can be held liable. Consider a bribery prosecution, a charge not at issue here, but one that provides a useful example. The federal bribery statute forbids any public official to seek or accept a thing of value for or because of any official act. The Constitution, of course, does not authorize a president to seek or accept bribes. At least it didn't used to before John Roberts got his hand on it. So the government may prosecute him if he does so. Yet excluding from trial any mention of the official act connected to the bribe would hamstring the prosecution. To make sense of charges alleging a quid pro quo, the jury must be allowed to hear about both the quid and the quo, even if the quo standing alone could not be a basis for the president's criminal liability. She notes that the rules of evidence allow for addressing any concerns appeal might have of excluding prejudicial material, if that's what Roberts is concerned about. This ruling from Roberts alone, the evidence bit, just alone, makes presidents functionally immune for pretty much anything. If you can't use evidence from their presidency to prove that they did something wrong during their presidency, you're never going to prove they did something wrong during their presidency, whether it's official or unofficial. Let's get to the dissents. I'm sorry I'm yelling so much, but just like I said in PEP 166 last podcast, I can't tell you how much this has shaken me. Like, honestly. I mean, that's a bit overdramatic, shaken, but like I had so much faith in John Roberts to not be like this. I don't know what to expect from him anymore. I mean, he wasn't my hero or anything, but I gave him the benefit of the doubt. And he totally betrayed that benefit of the doubt. Not just to me, but to his country. Let's go to the dissents. Sotomayor. Looking beyond the fate of this particular prosecution, the long-term consequences of today's decision are stark. The court effectively creates a law-free zone around the president, upsetting the status quo that has existed since the founding. This new official acts immunity now lies about like a loaded weapon for any president that wishes to place his own interests, his own political survival, or his own financial gain above the interests of the nation. The President of the United States is the most powerful person in the country, possibly the world. When he uses his official powers in any way, under the majority's reasoning, he now will be insulated from criminal prosecution. Orders the Navy SEAL Team 6 to assassinate a political rival? Immune. Organises a military coup to hold on to power? Immune. Takes a bribe in exchange for a pardon? Immune, 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 immune. Let the president violate the law. Let him exploit the trappings of his office for personal gain. Let him use his official power for evil ends. Because if he knew that he may one day face liability for breaking the law, he might not be as bold and fearless as we would like him to be. That is the majority's message today. Even if these nightmare scenarios never play out, and I pray they never do, the damage has been done. The relationship between the president and the people he serves has shifted irrevocably. In every use of official power, the president is now a king above the law. Now, I'm not saying that that's definitely true, because remember what I said about uncertainty. There's a lot of uncertainty and wiggle room in this judgment. They might redefine it in the future to basically just be non-existent. But it may be true. What she's saying may be true. We don't know that it's not true. And that's problem enough as far as I'm concerned. And I do agree with her about the damage being done. I'll explain why a little bit later on. This was Roberts' response, by the way, to what I just read. The dissent's positions in the end boil down to ignoring the Constitution's separation of powers and the court's precedent, and instead fear-mongering on the basis of extreme hypotheticals about a future where the president feels empowered to violate federal criminal law. The dissents overlook the more likely prospect of an executive branch that cannibalizes itself, with each successive president free to prosecute his predecessors, yet unable to boldly and fearlessly carry out his duties for fear that he may be next. You smug prick, John Roberts. Okay, what do I think about all this? Well, obviously I don't like it, but let me tell you why. I think the problems he identifies are real. The cannibalization he described is real. He has real concerns. Let me make that really clear. If there was no immunity, what the district court judge found and the DC Circuit Court found of saying there was no immunity, I disagree with that. I think there should be some immunity. I think John Roberts' logic is correct. But the president being too timid, that's not a problem we have had since maybe Jimmy Carter. The problem we have today is of an overpowering, unaccountable presidency. It's a massive problem, and it's getting worse, and you just made it worse again, John Roberts. And you know what? If you wanted to deal with the first problem, the problem of cannibalization that you're concerned about, you can do it. You can do it really easily without committing violence to the Constitution. There are people smacking you across the face trying to tell you how you do it, which we'll talk about in a second. My problems, let's go through them. First of all, the complete lack of textual support from supposed originalists. Just like the 14th Amendment case that we talked about a few months back, the one about Trump being struck off the ballot, right? They pretty much pulled that one out of their asses, and they've done it again. Nowhere in the Constitution did it have any of their logic from the 14th Amendment case, and nowhere does it have any of their logic here. And you know what? It's not like the Founding Fathers didn't know about immunity. They chose not to institute any immunity. Several states gave their governors immunity at the time. It was a concept, okay? It was a concept that they were aware of. Alexander Hamilton in Federalist number 69, here's a bit of precedent that John Roberts didn't cite. He wrote that former presidents would be liable to prosecution and punishment in the ordinary course of law. He said that was an important distinction between the King of Great Britain, who was sacred and inviolable, and the President of the United States, who would be amenable to personal punishment and disgrace. He said the president should be subject to personal responsibility for his actions. He said the president should stand upon no better ground than a governor of New York, and upon worse ground than the governors of Maryland and Delaware, who had some immunity. He said they should stand on worse ground than those guys. And they didn't have complete immunity, just some immunity. Delegate Charles Pinckney at the time stated that the convention which formed the Constitution well knew that no subject had been more abused than privilege, and so it determined to limit privilege to what was necessary and no more. No privilege was intended for the executive, he said. And by the way, everything I just read, I'm not some super sleuth. I didn't hire Blue's Clues to find it for me. That was in Sotomayor's dissent. Roberts had no response for that whatsoever. He just ignored the originalist evidence. I would suggest that immunity actually goes against the very spirit of the Constitution. That's what I would suggest. But more importantly than that, if you don't pay any attention to that, there's only one mention of this issue in the Constitution, and it refutes immunity. Article 1, Section 3, Clause 7, the impeachment clause, specifies that the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. Do you recall that Trump's own lawyers at impeachment said that senators shouldn't convict him because if there was evidence of wrongdoing, Trump could and should be criminally prosecuted? They were Trump's lawyers. They said he should be criminally prosecuted if they've got evidence. So the founders assumed that the president can be prosecuted. They contemplated the president being arrested, and they didn't feel the need to mention any immunity, like they did for Congress at one point in the Constitution. The founders' intention is clearly not for immunity. In fact, you could say that Roberts, just with his ruling just now, declared the Constitution itself unconstitutional. Some kind of originalist, John Roberts is. By the way, that one precedent that they cited liberally, Nixon versus Fitzgerald, which declared immunity for civil actions, specifically said, quote, there is a lesser public interest in actions for civil damages than, for example, in criminal prosecutions. So even their own hand-picked precedent undermines their case by saying there is a public interest in criminal prosecutions. They ignored that. They just took the one half a sentence out of that precedent that served their purposes and ignored everything else. Yeah, good judgment, good ruling. Number two, absolute immunity. I hate that anyone gets absolute immunity for anything in this ruling. Take pardons. The Constitution explicitly grants the chief executive the power to grant reprieves and pardons for offences against the United States. So, with absolute immunity, the president can hire a goon to impose whatever punishment he likes on the public. He can hire a goon force to impose a reign of terror, and then he can pardon them all. That's fine. Under his powers, that's fine. The president could literally get up on TV and announce that he was offering pardons for $1 billion a pop. Apparently that's constitutional now. You can do that. It's immune. You're immune. No problems. Political prosecutions are now okay. Quote Roberts, the executive branch has exclusive authority and absolute discretion to decide which crimes to investigate and prosecute. And thus Trump's conversations with Justice Department officials fall within his conclusive and preclusive authority. That's the first time I'm aware of that the Supreme Court has given its tolerance and assent of explicit tyranny. I can't remember any other time. Explicit tyranny, that the government can get the Justice Department to do whatever the hell he wants to anyone. Now, sure, they've protected the former president from being exposed to tyranny, so he can act boldly when he wants to. But every other American now has had the threat ramped up considerably against them, thanks to this ruling. That's how you get the SEAL Team 6 scenario, from this absolute immunity. Do you remember, by the way, how the DC Court of Appeals asked John Sauer if the president could get SEAL Team 6 to assassinate his rival? Do you remember his response? He said, only if the president hasn't been impeached and convicted. Now, that, of course, was nonsense. Everyone ignored that. The Supreme Court also dismissed that. We all laughed at it. John Roberts just went further than that. He said, even if the president has been impeached and convicted, he's still immune from prosecution. Can you believe it? That we've gone further than what John Sauer put up as an ambit claim. I don't think he was even serious. I think it was an ambit claim for negotiation purposes. John Roberts has gone, yeah, and he's pushed it further. Look, there has to be limits. Immunity is fine. There has to be limits to prosecutions. I get that. I keep on saying that. And there are two obvious limits. Two obvious limits. You can have your immunity, but consider intent. This whole we're not considering intent thing, I don't know where that came from. It makes no sense. A corrupt use of powers, that can't be part of their official function. That can't be part of the constitutional power to executive authority to be corrupt. Consider their intent, for Christ's sake. That's one thing you could do. And then just rule out a corrupt use of powers. That would make all the difference in the world. If you could do that, that'd be fine. I'd be okay with that. Then the rest can have immunity. So you don't have the Section 371 problem anymore. That'd be fine. Or, number two, make the use of his powers presumptively immune, all of them, but no absolute immunity, but just make all his powers presumptively immune, and allow them to be rebutted if the president's actions are not covered by a simple clause. The president shall take care that the laws be faithfully executed. You know what, John Roberts? That's straight out of the Constitution. The president shall take care that the laws be faithfully executed. I underline and bold the words faithfully executed. That's what the Constitution says. That's what they shall do. Not might do, not could do, not it'd be nice for them to do, not it's none of our business if they do it. They shall take care that the laws are faithfully executed, including by themselves. If you give them presumptive immunity, but you can defeat that immunity by showing that they did not faithfully try to take care that the laws were faithfully executed, that's a good result. You get your immunity. The presidents can be as bold as they like, but they can't be tyrants. It'd be so easy. Number three, this is my third problem, the standard by which official acts are defined. There's a presumption there that presidential acts are official. I hate that. This has been largely unnoticed, but Amy Coney Barrett suggested the exact opposite, which is why I think she's closer to a dissent than a concurrence, even though she agrees with all the immunity talk and the fact there should be immunity and all that kind of stuff. Her standards are totally different to Roberts' standards. She said, properly conceived, the president's constitutional protection from prosecution is narrow. She worried that the court leaves open the possibility the Constitution forbids prosecuting the president for any official conduct. I agree. Her suggestion was this: the Constitution does not insulate presidents from criminal liability for official acts, but any statute regulating the exercise of executive power is subject to a constitutional challenge. A criminal statute is no exception. Thus, a president facing prosecution may challenge the constitutionality of a criminal statute as applied to official acts alleged in the indictment. If that challenge fails, however, he must stand trial. So she's talking about a two-step process. Number one, does the statute apply? Number two, is the application to the particular facts constitutional? Now, maybe I'm misinterpreting her, but the way I read this, it sounds like she's reversed the burden of proof. Rather than presuming that acts are official and likely immune, like John Roberts is, she's presuming that they're not immune. She's saying, first of all, see if the charge applies to the president, and then see if he's immune. So if he's not explicitly immune, then you keep on going. So they have to prove he's immune. Not prove he's not immune to exclude it. They have to prove he's immune to include it. So she's reversed the burden of proof. That's subtle, and some people might not get the significance of that, but it's huge. Honestly, especially with this kind of stuff, that's a huge difference. And it's been largely overlooked by the legal writers that I've read. So look, maybe I'm wrong on my interpretation, but that's how I interpret what she said. And you know what? If she didn't say that, then she should have said it, because I agree with that. I think that makes sense. But I think she did say it. Fourth, the way you defeat the presumption of immunity. Bring the balancing test back, for Christ's sake. The balancing test that you butchered from the precedent, from Nixon versus Fitzgerald. The balancing test is great. You could eliminate everything I just said. If you just apply the balancing test, you have presumptive immunity unless the public interest outweighs it, the public interest of a criminal prosecution. Simple. You as a judge make your judgment. Weigh one against the other. What a treacherous hypocrite, really. I just can't believe this guy, the way he butchered that precedent. Intentionally, of course. And of course, you need to be able to consider their motives for the balancing test. Of course, you need to consider their motives. The motives are all that matters. Fifth, the evidence section, that's just appalling. Don't even get me started on that. That is constitutional vandalism. I can't believe the way they're excluding evidence from official acts. That's just insane. That alone makes this ruling so much worse. The sixth is, I haven't even mentioned the delay. Remember we talked about the delay up to now? The fact that once they decide to go for a complicated immunity test, Trump was never going to face this trial before the election. That was never going to happen, okay? I was saying that before. They didn't need to do all this bullshit to save Trump. If they wanted to push this past the election for Trump, they could do that easily. Amy Coney Barrett would have. Everything I just said would have pushed it past the trial. But we wouldn't have opened up America to a future tyrant. But the delay continued. It's just rubbing salt in the wounds. They left this ruling to the last second. It was literally the last second, the 1st of July. They could have handed this down 3 weeks, 4 weeks earlier, and it was just a big middle finger to people who are trying to hold Trump accountable. John Roberts has the irrits of people charging Donald Trump, and he wants to get in their face. That's what this is all about. What a shitty judge. Like, honestly, appalling. And yeah, and this was him just rubbing it in, pushing it till the very last second before they revealed the ruling. It's a tantrum, essentially. This is a judicial tantrum. That's what this is. I should also say Roberts did take a ping at the DC Court of Appeals at one point in time too. He said, despite the unprecedented nature of this case and the very significant constitutional questions that it raises, the lower courts rendered their decisions on a highly expedited basis. That is a criticism, my friends. So they're all the things that I dislike about this ruling. Quite a few. Oh, finally, I should mention Clarence Thomas. What a dick. I don't want to spend too much time on Clarence Thomas's concurrence. He was one out. Everyone ignored him. I don't think his judgment deserves time, to be honest. But he basically agreed with Roberts. And then he spent most of his concurrence trying to argue that Jack Smith shouldn't be able to prosecute anyone, ever. Because in Thomas's view, the Office for the Special Counsel hasn't been established by law as the Constitution requires. The idea that Clarence Thomas was happy to allow presidents to murder people with impunity, but the abuse of power he was most concerned about was the creation of special counsels. That just drives me crazy. But you know why he did that? I'll tell you why he did that. Eileen Cannon is currently judging that exact issue right now in Florida. And Thomas was clearly talking straight to her. So he decided to hijack what may end up being the most important constitutional ruling ever. If they rule the wrong way, like if they don't narrow it down, if they keep it this broad, it's not an exaggeration to say that this could be the end of democracy. Quite literally, no exaggeration. This is the tools by which someone ends the American system. In that ruling, Clarence Thomas is most concerned about taking the time to address an argument that wasn't even raised in any serious capacity, just so he can word up Eileen Cannon how she can come up with some arguments to let Trump off the documents charges, which everyone knows are the real charges. Everyone knows they're the ones that he's going down for. And so Clarence Thomas wants to help Eileen Cannon come up with reasons to dismiss them. and let Trump, even though Trump will get off anyway if he wins the election, just to make sure he gets off. Once again, just to rub the left's face into it, in the dirt. You know, it's just, that's his priority. He's worried about that, not about this ruling, Mr. Originalist. So what does it mean? Does Trump get off? Not necessarily. We got no idea. There's so much uncertainty. It means there will be a very lengthy process in deciding what can be charged with, what evidence they can use against them. We don't know. We know it will be appealed all the way to the Supreme Court in 12 months' time. That's what we know. This could affect the Manhattan case. That's why the Manhattan sentencing has been put off. A lot of people have said, have expressed confusion about that. They're going, how can the Manhattan situation be official conduct? It's about him paying off a porn star before he was president. How? How can this be affected? I'll tell you how. It's that bloody evidence section, the section I hate so much, because some of that evidence was from 2017 when he was president. How much of the president's conversations in 2017 could come under official acts? His conversations with Cohen, his conversations with Hope Hicks, his conversations with anyone in 2017. How many of them come under official acts? We don't know. We're not sure, but whichever ones do, you can't use that evidence. So did they introduce evidence from say Cohen or Hope Hicks that was important evidence that then led to Trump being found guilty? If so, it's a mistrial and they have to start again without key bits of evidence. So that's the reason why this could affect the Manhattan case, because the evidence. Oh my God. Another thing this means, the new way to get a president ain't going to be getting a president by themselves, going directly to the president. It'll be going through their subordinates. First thing Jack Smith should do is just charge as many of Trump's subordinates as possible, even though Trump can pardon them all if he becomes president. In the SEAL Team 6 example, Trump's immune. SEAL Team 6 ain't immune. So that's what you do. You have to get everyone who helps him. Yes, the president is immune from pardoning all these people. They can pardon all of them and then you can't get them. But you can only pardon them while he's president. If the crime comes out after he's president, then you can get them. So expect that in the future. The books to be thrown real hard at the president's accomplices whenever you can get them. They won't be messing around with minimum sentences with these guys. If you are involved in some corrupt activity with the president and they can get you after the president's term is up, expect to go to jail for a long time, because that's the only way they can provide disincentive from all this corruption. We'll see if Jack Smith might not be able to do that. We'll see. Does this mean the USA is a sitting duck for a tyrant? Once again, not necessarily. I know I said it could, and it could, but maybe the first time this goes to court, they narrow this ruling incredibly. It's so vague, they could narrow it down to nothing. So maybe this is nothing. Maybe this is, like I said before, that's a tantrum about Trump being charged, and they have no intention of following through. Then again, the people who judge this in the future might not be them. Maybe it might be some crazy judge that Trump appoints in the next term. Maybe he's about to appoint 2 super crazy judges, and maybe in 30 years' time, one of them will be the Chief Justice, and they will allow all this shit to happen. We don't know. That's the funny thing about Supreme Court. When you mess around with the Constitution like this, sometimes there are horrible consequences. You just don't know. And here's the important thing. Remember I said before about the damage has been done? I agree with Sotomayor. It's because of this. Going forward, the lines for all presidents may well have just been redrawn for good. Because whether they mean it or not, it doesn't matter. The outer bounds of what a president can theoretically do have just been redrawn. So that means the bounds of acceptable conduct will also have just been redrawn. I'm not saying it'll be acceptable to do the SEAL Team 6 scenario. That's over the top. But things that until now wouldn't have been contemplated, all of a sudden will be contemplated. What they call the Overton window has just moved in a big way. What people would conceive as a possible realistic outcome has just changed. So when there's an important issue, like say terrorism or COVID or protecting the border or abortion or climate change, anything where they can go, oh, people will die, anything where people can fearmonger, which is a lot of issues, people will demand the president to go as hard as they can to deal with it. The definition of as hard as you can has just changed thanks to John Roberts. If a president doesn't push it further, people want to know why. They'll say, you have the power. You have the power to do this. Why don't you use your power? Don't you care? Aren't you a fighter? Do you want people to die? All of a sudden, things they never would have considered doing, they're going to explicitly have the power for, and there'll be pressure from their base to act on those powers. Even if no president is out and out corrupt in the future, and sorry, I reckon at least one of them might be, but even if no president is out and out corrupt, and no president pushes the absolute disaster scenarios that we've discussed, the entire presidency, because of what I just said, is about to become several steps more authoritarian. John Roberts, that's your legacy right there. A much more authoritarian country. By the way, what was Trump's reaction to this all? Big win for our Constitution and democracy. Proud to be an American. That came the day after he retweeted this. Elizabeth Lynn Cheney is guilty of treason. Read truth if you want televised military tribunals. Richie was joking about this in PEP 166. We've been joking about televised military tribunals ever since. I'm going to read it one more time. Elizabeth Lynn Cheney is guilty of treason. Read truth if you want televised military tribunals. He doesn't know what treason means. It means nothing like that. And he's talking about televised military tribunals. Oh my God. Anyway, it makes me very depressed. I'm not saying that that's going to happen. He's obviously just emoting like he always does, and he's not serious or whatever. Sure. So don't misquote me. I'm not saying the televised military tribunals are coming, but something's coming. Not necessarily from Trump, but someone. Because like I said, the boundaries have all moved way back to the point where you can't even see them anymore. I want to read a correspondence from Aussie Cowboy. What's to stop Biden exercising these powers? i.e. he could SEAL Team 6 Trump. The outcome would surely be horrendous, but would it be better or worse than Trump doing similar in a year's time? So many people have talked about this, so that's why I think this is good to address this. I don't think Trump is going to do that. In fact, I don't think anyone's going to do that. Even in my nightmare scenarios, I don't think SEAL Team 6ing your opponent is on the cards, even in 50 years' time. Maybe it's unwise for me to say that. I don't think it's going to happen. That would be insane. Not even Iran or Russia do that kind of thing. When Putin has people murdered, it's not by SEAL Team 6. They meet with an accident, okay? Or they jowl you. That's. I think the dangers, I'll tell you where I think the dangers are. How the pardon power is used. Trump already used the pardon power in a corrupt fashion, if you ask me, in term 1. Term 2, God knows how far he's going with that pardon power. Now he's immune. I think how political the DOJ becomes is a real concern under Trump and under the people in the future, because there's a lot of talk as if Biden was the puppet master for Trump's trials and of his charges. Look, I think even the puppet master types would concede that Biden wasn't all over it in a really obvious way, even if he was slightly giving a bit of a nudge and a wink. But this can open the door to the president's being openly political, just owning it. That's a whole new world, and not a good one. I also am concerned about how the military is going to be used. Not for SEAL Team 6, but immigration. I can see some real nasty shit done to potential migrants by the military in this term and in future terms. Also, I've got a lot of concerns about how protesters are going to be treated in the future. I can see some real nasty stuff done. Recall, whether it's true or not, that Trump, according to what's his name, Brett, his last defense minister, whoever that guy's name was, Brett, the guy with the glasses, forgotten. Whatever, according to him, Trump explicitly wanted them to shoot at the legs of the protesters during the George Floyd protests. Not to kill them, just to stop them. That was term 1. What happens in term 2? What happens in 20 years? What happens in 30 years? That's where I'm concerned. The military being used against American public and immigrants. How political the Department of Justice is, how the pardon power is being used. And that's bad enough, honestly. If Biden did do what you're saying, if he took out Trump with SEAL Team 6, he wouldn't be jailed. But although I do think they would narrow that ruling real fast, the Supreme Court, if Biden did do that. Remember all the wriggle room they've left. So maybe he would go to jail. But according to this ruling, he wouldn't go to jail. He would be immediately impeached. And he would be removed. If he used SEAL Team 6 to take out Trump, he would be removed. They would get enough votes. The Democrats would be destroyed in the election. It would be the beginning of a conservative era, a glorious conservative era, probably with extreme conservatives, because the people they would put in after Trump was assassinated would be absolute nutbags. There would be revenge on their mind. So that would be a bad idea for Biden to do that. Even from a pragmatic point of view, it would be a terrible idea. What I think Biden should do, normally I would say you shouldn't politicize the Supreme Court. But man, on this one, even I'm on board for politicizing this. Like, if I was Biden, I would campaign the hell out of that law, or that ruling from today until election day. It would be all I said. I'd make sure every single person knew that America was on the line because of the Supreme Court. I would not shut up about this. And yeah, that's an area that Kamala Harris might actually do better than him. She's the, I know he's supposedly an ex-lawyer, but she's really an ex-lawyer. And Attorney General, she can be precise. She can be severe. I could see her potentially doing that well. We'll find out. But that's what I think he should do. He shouldn't murder people. Don't murder people. That's it for that section. That's probably enough. I'll tell you what I'll leave you with. I got another 20 minutes. I'm not going to use it, but I'll leave you with a stats nugget. Stats nugget. It's the end of the term, so there's a bunch of stats out about the judges in this term and their lifetime ratings. This term, 45.8% of cases were unanimous, which was actually down slightly from last term, higher than the year before, which was 26.4%, and then higher than all 3 years before that. And it includes some of those unanimous cases involve some controversial cases, like the like Trump being on the ballot, like the mifepristone case, the NRA lawsuit against New York. There were some controversial ones there. So, yeah, people think the court is all partisan. Pretty much half unanimous. Unanimous. There were 22 cases decided 6-3, but only half of those were entirely partisan. The others were mixed bags. So there are only 11 cases out of the 160 or so that were actually partisan, like fully partisan, which is less than you might think. 2 of the 4 most conservative justices since 937 are on the current court, as far as lifetime ratings go. Clarence Thomas is one of them. Sam Alito is the other one. The other 2, in case you're interested, were William Rehnquist and Warren Burger. 2 of the 5 most liberal justices are currently on the court. Sonia Sotomayor and Ketanji Brown Jackson. The others, in case you're interested, were Thurgood Marshall, William Brennan, and William Douglas. This term, Roberts was in the majority in divided cases 94% of the time, more than any other member of the court. No other Chief Justice since at least 953 has been in the majority as often as that. So this was his court. This was really his court. Kavanaugh, though, has the highest lifetime record for being in the majority of decided cases, 89% of the time. So there you go. Kavanaugh is usually the median vote, at least so far. This term, things are changing a little bit. Let me show you a graph of what you can see this term compared to the last term. And what you'll notice is that Kavanaugh isn't quite as liberal anymore. That graph is showing you how liberal, what percentage of their rulings they ruled on the liberal side. Obviously, the 3 democratically appointed judges are right up the top there. But interestingly, Roberts and Kavanaugh have become less liberal, whereas Gorsuch and Barrett have become more liberal. Since he joined the court in 2017, Gorsuch has voted for the government just 35% of the time. I told you that before. The lowest rate of any member on the court. He doesn't like the government. And this term, as you can see in that graph, Barrett overtook Roberts as the Republican appointee, casting the highest percentage of liberal votes in divided cases. So Gorsuch and Barrett seem to be drifting left, and Roberts and Kavanaugh seem to be drifting right, at least for this term. We'll see what happens. I mean, Barrett's definitely drifting left. I will talk more about this another time. Anyway, so there's your stats nugget. I think I've talked enough about the Supreme Court. I got pretty angry, but honestly, if you're not getting angry about that immunity ruling, you're never getting angry if you understand the law. I can't believe them. I used this phrase before, they have done violence to the Constitution. It's so bad. John Roberts, what are you doing? Anyway, on that cheery note, I will leave you. Reminder, on Friday, we've got the highly dangerous, I would have thought, Try-Podcast with Richie, Dr. Dave and I all squeezing into that little studio. 3-person podcast. What's going to happen? Who knows? All I know is that we're not going to spend 2.5 hours talking about the Supreme Court. So because of this. So I hope that this wasn't too much content for you over the last 2 days. I imagine a lot of you are listening to this in a week's time, if at all. But thank you very much. I hope it at least did the trick for you guys, because this stuff is obviously important to me. I will see you guys on Friday. Until then, stay peppy.